Hello, I'm Ohio Attorney General Mike DeWine, and today we're going to talk about the United States Constitution.
After the Revolutionary War, the leaders of our young nation were concerned about the proper role of government. They held a constitutional convention in Philadelphia to decide how the former colonies would govern themselves. These leaders, who had lived under a king before the Revolutionary War, became known as the Founding Fathers. They did not want to return to a system that concentrated power in one person. That was the kind of system they had fought hard to break away from. James Madison, one of the Founding Fathers, summarized his view on the dangers of concentrated power when writing a series of essays known as the Federalist Papers. In the Federalist number 47, Madison stated,
"The accumulation of all powers, legislative, executive, and judiciary, in the same hands, may justly be pronounced the very definition of tyranny."
To address this concern, the drafters divided these functions and powers. They designed the federal government to have three equal parts: the executive, legislative, and judicial branches.
Each branch of government has an independent role to play, with its own unique powers. This is what we call the separation of powers. Each branch checks and balances the other two, so that no branch becomes too powerful. This three-part structure of the federal government was so important to the framers that they put it at the front of the Constitution in Articles 1, 2, and 3.
Article 1 governs the legislative branch. The legislative branch is comprised of the House of Representatives and the Senate, which are together known as the U.S. Congress. As explained in Sections 2 and 3 of Article 1, each state is represented by 2 senators regardless of the size of the state. But the number of representatives from each state differs based on the population of that state. For example, Ohio has 16 representatives, while Rhode Island has only 2, because Ohio's population is much greater than the population of Rhode Island. Sections 2 and 3 of Article 1 also lay out the qualifications for becoming a senator or representative and explain how and when they are to be elected. The Constitution empowers the legislature to set the budget, declare war, and approve the appointment of federal judges, among other powers set out in Article 1. But the legislature's primary purpose is to write bills and make laws. To stop the legislature from becoming too powerful, the Constitution requires that the President sign any bill passed by Congress before it can be enforced. The President's decision whether or not to sign a bill into law is called the President's veto power.
During my time in the U.S. House of Representatives and then in the United States Senate, a number of the bills that I drafted were signed into law by the President.
Despite the President's crucial role in passing laws, the President is not part of the legislative branch. The President is the head of the executive branch. The executive branch is set out in Article 2 of the Constitution. The executive branch consists of the President, Vice President, and members of the President's cabinet and staff. It also includes dozens of federal agencies. In all, more than 3 million Americans work for the executive branch. In addition to giving the President the power to enforce the laws passed by Congress, Article 2 also makes the President the Commander-in-Chief of the Armed Forces and gives the President the power to conduct foreign policy. With the advice and consent of the Senate, the President can also nominate and appoint ambassadors, federal judges, and Supreme Court justices. The third branch of the government, the judicial branch, is established in Article 3 of the Constitution. The judicial branch interprets the laws passed by Congress and enforced by the executive branch to make sure that they comply with the Constitution's protections. The judicial branch is comprised of courts at 3 levels: federal district courts, where civil and criminal trials are conducted, the courts of appeals, and the United States Supreme Court, where 9 justices hear appeals from the Court of Appeals and from the state Supreme Courts. Establishing the 3 branches of government is not all that the Constitution does. In fact, the articles establishing the legislative, executive, and judicial branches make up less than half of the 7 articles found in the Constitution. Article 5 addresses the ways in which amendments to the Constitution may be made. Article 6 contains the Supremacy Clause, which holds that federal law will prevail over any conflicting state law, including provisions of state constitutions. And Article 7 describes the process for ratification.
Our founders drafted a constitution like none before it. 3 equal parts of government, each one checking on the other. But before the Constitution could be enforced, it had to be passed by 9 of the 13 colonies. Ratification was much more difficult than our founders thought it would be. To help ensure the passage of the Constitution, the Bill of Rights was added. Stay tuned. We'll teach you all about that, the Bill of Rights, in another video.